chits, we have a third court clerk who will be handing the material over. The judges will be arriving shortly, so once they arrive, I request everybody to stand up. Thank you.
ये बंद हो गया। Wait, बंद हो गया।
Permission to approach the dais. Much obliged. The dais. Much obliged. Greetings. The Council acknowledges the gracious presence of the bench. However, for the sake of the brevity of the proceedings, seeks the kind consent to collectively address the bench as your lordships. Much obliged. The Council stands before this honorable court today representing the petitioner, which is Dr. Dhulkifil Mohammed Naik, in the case of Dr. Dhulkifil Mohammed Naik versus the Republic of Arcadia, wherein we contend that there is a breach of our fundamental right under Article 25 of the Constitution by way of a special leave petition under Article 136 of the Constitution of Arcadia. Before delving into the submissions, the Council would like to highlight in this court of law that the laws and Constitution of Arcadia stand in pari materia to the laws and Constitution of India. If it appeases this honorable court, the Council would like to provide your lordships with a short summary of the facts that led up to the filing of this case. Stating very briefly, in the Republic of Arcadia, which is a diverse nation with strong democratic foundation, Dr. Dhulkifil Mohammed Naik is a respected Islamic scholar and citizen who was denied his right to vote in the 2019 general elections due to a conflict between his religious practice of wudu and the mandatory election ink marking as per the ECRA rules. Despite this contention being dismissed by the lower court, Dr. Dhulkifil now seeks relief from the Supreme Court, arguing for the protection of his fundamental right under the Constitution. In the light of these circumstances, there are 4 issues upon which the counsel for the petitioners will be arguing upon. As the first counsel, I shall be taking up issues 1 and 4 for a total of 12 minutes, and my co-counsel will be taking up issues 2 and 3. For the easement of your lordships, a roadmap to the issues 1 and 4 is provided as follows. Issue 1 deals with how the petition is maintainable under Article 136 upon jurisdictional and meritorious grounds, and issue 4 deals with how the petitioner's interests is in adherence to the reasonable accommodation principle. If your lordships have no preliminary queries, the council would like to move to the submissions. Much obliged, your lordships. Upon arguing on the first issue as to how the petition is maintainable, there is a 3-pronged approach that the council will be following. First, that the present petition involves a substantial question of law. Second, that there are exceptional circumstances necessitating this petition. And third, how there are no alternate remedies for the petitioners to seek. Coming to the first limb of the argument, the council would like to highlight the case of Sir Chinni Lal V. Mehta and Sons Limited versus Century Spinning and Manufacturing Co., which lays down a test to establish whether a question is a substantial question of law upon 3 grounds, which are as follows. First, whether the question of law is of general public importance. Second, whether it substantially affects the rights of the parties. And third, whether it is a well-settled position of law without any difficulty. Firstly, in this petition, it is respectfully contended that the current election rules, specifically the requirement of applying election ink, infringe upon the rights guaranteed under Article 25. This mandate obstructs the petitioner's ability to perform wudu, which is a fundamental religious practice necessary for offering daily prayers. Such impediment.
Sorry to interrupt.
Yes.
Due to positive time, can you just quickly come and convince the bench why you haven't approached us by virtue of Article 32?
Yes, your
Instead
lordship,
of-
certainly. Your Lordship, the Council of Petitioners stands before this court today under Article 136 and not Article 32. Since to go under Article 32, it would necessitate a fresh petition altogether under the original jurisdiction of the Supreme Court. Further, the Council for the Petitioner would wanted to approach the High Court. So,
Problem if you have to go ahead with a fresh petition.
Your Lordship, coming to that, the second answer to that would be that the Council for Petition wanted to approach the High Court first, so as to exhaust all alternate remedies possible, so that that particular question does not come into play. That the petitioners could have approached the High
So if
Court
there's an
first.
emergency, if it is so essential question of law, why do you want to, keep on following the remedies which are there? If
Certainly,
it's a
Your Lordship.
fundamental right and if it is affecting your rights so vehemently, why don't you want a speedy disposal?
If the Council for Petitioner can get 10 seconds for the answer. Thank you, Your Lordship. Your Lordship, the council believes that they wanted to follow a proper procedural aspect, because if otherwise the council were to approach this court under Article 132, the one looming question would have been from the respondent side that one of the most important arguments from their side would have been how the council should have approached alternate remedies before coming under.
To argue on the basis of the strength of your case or on presumption of what your opponent is going to say?
Understood, Your Lordship. Your Lordship, the council believes that it's not as if the High Court under Article 136 cannot also speedily speedily establish the question of law, Your Lordship. Coming to the first limb, how it is a case of general public importance. Under the case of S.P. Gupta versus Union of India, it has been given your lordships have been given the power to interpret the constitution in a way to safeguard the fundamental rights of individuals. Further, this mandate obstructs the petitioner's ability to perform wudu, which is a fundamental religious practice necessary for offering daily prayers, which my co-counsel will be establishing under issue 2. Such impediment not only affects the petitioner individually, but also encroaches upon the religious rights of the entire community.
What is the citation of S.P. Gupta?
Just a moment, Your Lordship. Your Lordship, page number 2 of the memorial, citation number 6. If the council may proceed. Much obliged. Coming to the second sub-issue, how Mr. Naik's rights are substantially affected in this particular case. The crux of the matter lies in the imposition of a requirement to mark Mr. Dulkifil's left index finger in order to cast his vote, directly impeding his ability to fulfill his obligatory daily prayers. This mandated action directly contradicts the fundamental right to freely profess, practice, and propagate one's religion as protected under Article 25 of the Constitution of Arcadia, Your Lordships. Offering prayers is a cornerstone of the Islamic faith, mandated to be performed 5 times a day, Your Lordship. By performing prayers, these regulations significantly infringe upon the petitioner's constitutional right to practice as already established. Coming to the third sub-issue, it is to be proved that that there is not a well-settled position of law in this particular case, Your Lordship. The essence of the submission lies in the recognition that the case before this esteemed court introduces a novel challenge concerning the electoral rules for which there exists no definitive precedent addressing the intricacies of this case. This absence of established jurisprudence necessitates a meticulous examination to navigate through the complexities and conflicting interests involved, Your Lordship.
It's laid down for deciding and determining what are the essential religious functions.
Your Lordship, my co-counsel will be dealing with that entirely in the issue.
Could you quickly summarize?
Understood, Your Lordship. Just a second. Your Lordship, upon paragraph 22 of the moot proposition, the memorial, page number 6, it is established via para 20 and 21 of the submissions that wudu is an essential precondition of salah. It is also established through para 19.
Counsel, my question is, are there any parameters for determining in general, not specifically about this case, is there a jurisprudence that has been evolved either by the Supreme Court or by the theorist or jurist, which would lay down how do you evaluate what are the essential religious functions?
Understood, Your Lordship. Your Lordship, the test is given in the case of Sardar Saroop Singh versus State of Punjab upon 3 grounds, whether it is a core tenet of the practice, whether it is essential in nature, and whether it is the fundamental nature of the religion, Your Lordship.
Do you have a copy of the case?
No, Your Lordship, not the case.
Okay, please go ahead.
Much obliged, Your Lordship. Coming to the second sub-issue, the council shall move to arguing that there exist exceptional circumstances necessitating the petition. The petitioner respectfully draws attention to the principles governing the grant of special leave under Article 136, emphasizing its reserved nature for exceptional circumstances where grave injustice looms large. It is incumbent upon the court to discern features of sufficient gravity warranting a review on merits. The petitioner's contentions pivot around the infringement of the fundamental right to religious practice enshrined in the Constitution. Failure to intervene in this particular case would perpetuate this infringement by the state, constituting a grave injustice. The paramount.
Is the right absolute, counsel?
No, Your Lordship, the council understand there are reasonable restrictions, and my co-counsel will be dealing upon that in issue number 3.
If everything your co-counsel is going to deal with, what are you going to do here?
Your Lordship, I'm particularly dealing with the maintainability of the petition upon the grounds and how.
Is maintainability and the further issues disconnected from each other?
No,
They
Your
are part
Lordship.
and parcel.
No, Your Lordship. Your Lordship, would you want me to continue with the issue 1 itself, or? Right, yes, Your
We
Lordship.
are convinced that we have jurisdiction to try the matter. How would we continue, hearing your further arguments?
Understood, Your Lordship.
You agree that your preparation on your side is segregated in silos and your co-counsel's preparation is
Yes, Your
segregated.
Lordship.
May I ask the reason why is it so?
Your Lordship, that was just to divide the time in a way so that effectively all the issues can be dealt with instead of the councils taking up all the issues altogether, Your
Okay,
Lordship.
please go ahead.
Yes, Your Lordship. Coming to the 4th issue directly, Your Lordship, the council is going to prove here that the petitioner's interests are in adherence to the reasonable accommodation principle upon a two-pronged approach. First, that the impediment caused by the election rules amounts to indirect discrimination, and second, that such discrimination can be remedied with reasonable accommodation, Your Lordship. First limb of the argument says, in ascertaining the petitioner's case, it is crucial to address the issue of indirect discrimination resulting from the impungent election rules. Under Article 14 and 15 of the Constitution, the state is mandated to ensure equality before law and protection against discrimination on various grounds, including religion, Your Lordship. Indirect discrimination occurs when the application of law disproportionately impacts a protected group, as laid down in the case of Navtej Singh Johar versus Union of India as well, Your Lordship. Considering the paucity of time, if Your Lordship would grant the council. Understood, Your Lordship. Much obliged. Coming to the second sub-issue in the 4th issue, in addressing the issue of discrimination and its potential remedy through reasonable accommodation, the council here cites the case of Nalsa versus Union of India and Nitisha versus Union of India, which have recognized that the principle of non-discrimination extends beyond mere prevention to remedying systematic discrimination faced by individuals due to their identities, Your Lordship. This acknowledgement underscores the importance of reasonable accommodation as a facilitator of substantive equality, Your Lordship. Moreover, in instances like Ravinder Kumar Dhariwal versus Union of India, the court has held that the failure to provide reasonable accommodation may also amount to indirect discrimination. In the present circumstance, Your Lordship, the Election Commission has previously implemented reasonable accommodation measures to address systematic discrimination. For instance, measures aimed at increasing women's participation in the voting process, such as separate queues.
What do you mean? What do you mean by the term discrimination?
Your Lordship, the council under Article 14 on the ground of under Article 14 and 15 of the Constitution, it is given that the state cannot discriminate upon certain grounds, religion being one of them, Your Lordship.
How in your case you are being discriminated?
Yes, Your Lordship. Your Lordship, the council here argues that in this particular case, the rules which do not let.
Is it on the basis of discrimination is based on the rules or on the facts?
Your Lordship, but the rules itself do not let the petitioner.
What is the fact of discrimination?
Could you repeat your question, Your Lordship?
What is the fact which led to discrimination?
The not being able to right to vote, Your Lordship, and the breach of the Article 25 under the Constitution, Your Lordship.
So this continues with Honorable Justice's question. Is the fact of not being able to vote, or is the fact of putting the ink violative?
Your Lordship, the petitioner here argue. Could you repeat your question, Your Lordship?
So you're
Apologies.
pleading some right, right? Violation of some right.
Yes, Your Lordship.
And on the basis of that, as my brother judge had asked you, whether it was on fact or it was on. So here the question is whether it was the fact of not allowing the petitioner to vote, or is it on the fact that there is an indelible ink that is put on the figures?
Both, Your Lordship, it is not being upon that rule itself. The petitioner was not allowed to vote, Your Lordship. Here, the petitioners are not arguing that the petitioner was not on the electoral roll under Article 329 or whatsoever. It is just that the
So the question falls back to what is discrimination? Where you discriminated?
Your
Is
Lordship,
it a discrimination, a class discrimination on the basis of religion?
yes, Your Lordship, indeed, under Article
How?
14. Because under Article 14, the state cannot discriminate, 14 and 15, the state cannot discriminate on the basis of religion, right?
Does the state says that since you are performing voodoo, you will not be allowed to vote?
No, Your Lordship, but there does exist indirect discrimination the way that because of the ink and because of these rules, the petitioner is not able to perform wudu, Your Lordship.
So the basic question comes, which you should plead that what is the basic concept of wudu and how it infringes with the rights?
Your Lordship, my co-counsel is dealing with that in the issue too, Your Lordship.
Is right to vote absolute?
No, Your Lordship, it is
Are
a
there limitations?
constitutional right.
Are there limitations to the right?
Yes, Your Lordship.
What are the limitations?
The limitations being public order and morality under Article 25 as well.
Okay. So when you want to prove any right which has been violated, what is the title of the right? How do you prove that this right is vested in your petitioner?
Your Lordship, you would prove that that your particular case does not fall under the reasonable restrictions. Yes, Your Lordship.
Okay. So what are the titles that you will be proving here? That he has a right to vote
Yes, Your
and
Lordship.
he has a right to religion, and that these two rights are conflicting with each other.
Your Lordship, the petitioners are not arguing that the right to vote in itself is violated since it's a constitutional right. We are solely saying that there is a breach because of these rules. There is a breach of the Article 25, Your Lordship.
So isn't it a conflict?
Yes, Your Lordship, it is in conflict.
So how do we resolve these conflicts?
If the petitioner can be granted just 10 seconds for the perusal, Your Lordship. Your Lordship, the petitioner says that under issue 4 as already established, the reasonable accommodation principle is how the conflict between these two rights can be avoided, Your Lordship. Yes, Your Lordship. My co-counsel will now be dealing with issues 2 and 3. It was an honor arguing before this court, Your Lordship.
The counsel seeks permission to approach the dais. If your lordships are satisfied with the pleadings in the first and fourth issue, the council would like to proceed to the second and third issue. Much obliged, your lordship. Your lordship, the second issue pertains to election ink rules, and herein it is submitted that these election ink rules infringe upon the fundamental rights of the petitioner under Article 25. For the benefit of the court, the election rules under contemplation here are the conduct of election rules under Article 37 and 49K, as well as the Representation of People Act under Article 61 under Section 61, apologies, 61 and 61A of the Representation of People Act. Your Lordship, this submission is structured as follows. Firstly, that the effect of election rules amount to an infringement under Article 25. And secondly, following from that, such an infringement of Article 25 amounts to a violation of fundamental rights of the petitioner. Your Lordship, the first submission, which is that the effect of election rules amount to an infringement, is substantiated as follows. According to clarification 10 of the moot proposition, it is stated that the election ink which is placed on the index finger of the petitioner is resistant to washing. It only goes away after a few days and a few weeks. It only goes away after new skin cells replace the old skin cells. Your Lordship, this speaks to two things. Firstly, that this election ink is resistant to washing, which shows that it's non-permeable in nature. Secondly, the fact that it goes away only after the new skin cells replace the old skin cells, that it presents barrier from the water to enter all parts of the body, particularly the nail in this question. Your Lordship, herein the council would like to address the contention of the respondent itself. Uh, Your Lordship, the respondents have contended that um, election rules pertaining to inking are unconstitutional. However, are not unconstitutional because of XYZ reasons. However, it is not petitioner's contention that these election rules themselves are unconstitutional. It is sought to be contended that these election rules infringe on the fundamental rights. Thereby, a distinction is drawn here. The burden on the petitioner side falls to only this particular part, that there is a infringement which is
Council, what is the purpose of election rules? What is the objective of the People's Representation Act and the procedure that has been created?
much obliged. Your ladyship, the purpose of these election rules are to prevent impersonation as stated under the marginal heading of these rules. Prevent impersonation of multiple voting and electoral fraud.
Right. So, if are there any other means and mechanisms for avoiding this impersonation?
Yes, your ladyship, there exist in practice multiple safeguards such as linking of Aadhaar card, which is practiced in a few areas, showing of electoral roll, showing of the voter ID, signature, and taking of biometrics.
Within the provision, are there any specific, while these new alternative mechanisms are created, on what basis you can plead them? Are there any rules as of now acknowledging it?
Your ladyship, the rules of the presiding officer's handbook of which is given to election officers at the time of electoral roll state that the polling officer has to confirm the identity of the voters using the voter ID card and take their signatures and take their thumb impression if that is the case, and then they will be presented with the indelible ink mark which will be checked by the polling officer.
Right. So, why can't this procedure be implemented?
Your ladyship, the procedure for indelible ink.
No, the procedure that you have explained is it's a substitute to indelible ink.
No,
right?
your ladyship, this exists in present. Your ladyship, it is submitted that because these safeguards already exist, indelible ink, which forms such a substantial infringement on fundamental rights of Article 25 of the petitioner, that this indelible ink should be given an alternative to, or the petitioner should be reasonably accommodated because there already exist other
So the
safeguards.
question is, are there such reasonable accommodations already there? Do the officers have a discretion of exercising them as per the provisions of the law?
Your ladyship, it is mandated upon polling officers to check that indelible ink is present under 37
Okay, okay.
of the election rules.
Yes, you continue.
Your ladyship, another contention of the respondents in this regard is that the election rules or the authority of the election commission is supreme and cannot be challenged, and they have a plenary authority. However, the petitioner in this under this case are in no way challenging the authority of this election commission, and we agree that the election commission has immense powers. However, these particular rules are in question. Now, coming to the second limb of our submission, which shows that Vudu is a core tenet of the religion. We will show that the infringement violates Article 25. Your Lordship, for the benefits of this court, Article 25's jurisprudence has evolved through the precedents of this honorable court in Sardar Syed, as well as in Dargah Committee versus Syed Hussain, as well as most recently in Shaira Bano. Your Lordship, three tests have been identified. Firstly, that this essential religious practice must be a core tenet of the religion. Secondly, that the consciousness of the people must give evidence as to the core tenet as well as the essentiality of the religion, of the practice of the religion. And thirdly, that authoritative text has to be presented. On basis of all this, in Shaira Banu, it was conclusively held that the definitive text to prove that something is an essential religious practice is that the fundamental nature of the religion would be changed without this practice. Your Lordship, it is this submission that is sought to be substantiated. Your Lordship, wudu is an essential precondition to salah. Wudu is something that attains ritual purity and is mentioned in the Quran as well in Surah Al-Maida, para 6. Your Lordship, it's stated that the procedure for wudu, although not mentioned explicitly as wudu in the Quran. It's agreed upon by all schools of fiqh jurisprudence that wudu exists in the Quran, and it's a practice that is imposed or is binding upon Muslims. Your Lordship, the respondent's submissions in this regard is that there exists an alternative to wudu in the form of tayammum. Your Lordship, it is the petitioner's, the respondent's argument overlooks the fact that tayammum is only prescribed under very specific circumstances. Your Lordship, these circumstances range from there being danger of life because due to disability or due to illness to there being no availability of water. These are very specific circumstances that are prescribed under which tayammum can be performed. Your Lordship, it is also stated that if there is availability of water and the petitioner or the Muslim who's seeking to perform prayer knows that there is availability of water and tayammum is performed in spite of that, the tayammum would not be valid. And if it is well established that if the wudu is not valid itself, the salah will not be valid. Your Lordship, it is well established that salah is an essential practice of the religion. It's a core tenet of the religion, which is mentioned in the Quran itself. Your Lordship, thereby it is sought to be substantiated in this regard that just because an exception to wudu exists in the form of tayyam, it does not form a loophole in the religion, so to speak, as to show that there exists an alternative, and thereby it's not an essential religious practice. The essentiality of the religion comes from the fact that authoritative text has been presented in the form of the Quran, in the form of hadith, and the jurisprudence of fiqh juris to show that wudu is an essential religious practice. Your Lordship, thereby it is respectfully submitted that the impugned election rules violate the fundamental right of the petitioner because the election ink which is placed on the indelible ink, A, presents an impediment to wudu, and wudu being an essential religious practice cannot be impeded upon in good faith by the Honorable State. Your Lordship, the Council seeks permission to the third submission. Much obliged, Your Lordship. Your Ladyship, the third submission deals with whether, if there is such an infringement, whether if such an infringement exists, it falls within reasonable restrictions. Your Ladyship, the reasonable restrictions contemplated under the Constitution, which are relevant to this particular the facts at hand, are the test of public order, the test of morality, and the proportionality test, which was propounded in multiple cases, such as most recently in the Gujarat Mazdoor Sabha Sangh. Lordship, firstly, dealing with public order. Lordship, when public order is dealt with under Article 25, what is meant is the preservation of public order. Lordship, an analysis of all the precedents which talk about public order, such as in Arun Kumar Ghosh, in Romesh Thapar, as well as in Indian Young Lawyers, for the honorable perusal of the bench. This is in, apologies, Your Lordship, page number 11 and page number 10 of the memorial. A perusal of all these precedents would show that invocation of public order is only done by this honorable court in very grave circumstances when there are chances of sectarian violence, when there is imminent public disorder. Your Lordship, in Indian Young Lawyers, it is held that public order is the opposite of public disorder. The preservation of public order must be shown in such a way that the absence or any amendment which is made to these rules would immediately have a rational nexus with public disorder. Your Lordship, what the petitioners submit here is that if there is a reasonable accommodation made for the petitioner in order to reconcile these two different facets of their identity as a patriot as well as a person who practices that religion, there would be no public disorder caused. Your Lordship, another facet of public order is that it must affect the life and tranquility of the community. The peace of the life and the land must be disturbed. Your Lordship, the respondents have failed to prove that there is any disturbance of peace that would amount as an immediate consequence of this of any amendment or infringement on these rules. Your Lordship.
Council, because of the paucity time, could you just, summarize the public order, morality, and health grounds, and then emphasize more on the
Much obliged.
proportionality?
Much obliged. Your Ladyship, the morality contention is of no relevance in this particular case from the respondent side because constitutional morality is what is meant by, in Sabrimala case, it is health morality should be held as congruent to constitutional morality. And constitutional morality protects the liberty of a person to practice their faith. Your Ladyship, moving on to the proportionality test as under the Honorable Judge's discretion. Your Lordship, the proportionality test was described by Justice Dhulia in the Ashwat Shifa case versus State of Karnataka, as well as in Gujarat Mazdoor Sangh. Your Ladyship, for the perusal of this court, this is from page number 14 to page number 18 of the memorial. Your Ladyship, the reasonable or the proportionality test holds that any legislation which seeks to infringe on a fundamental right must follow these three tests and must not infringe on these three tests. Your Ladyship, the first facet of this test is necessity. Your Ladyship, this brings it back to the original question which your Ladyship asked, wherein it was held that if the indelible ink is not the only safeguard. Your Ladyship, we bring it here as well, that because indelible ink is not the only safeguard in order to prevent impersonation, it does not become so necessary as to be allowed to exist even though such a massive infringement of the fundamental right of the petitioner is taking place. Your Ladyship, the second peg of this argument is about suitability. Your Ladyship, suitability under Merriam-Webster, which is an external aid to interpretation, will be relied upon. Your Ladyship, suitability means propriety. In various Supreme Court judgments, it has also been held that there must be a rational nexus between the means and the ends. Your Ladyship, what this necessarily means, it's that the rules must be effective. Your Ladyship, herein it is submitted that even with the presence of indelible ink, multiple voting happens. Impersonation does happen. In Manful Singh as well as in S. Kevaria, it was held that the indelible ink which existed on the index fingers of the petitioners, however, in spite of that, multiple voting had happened. Your Ladyship, this shows that despite the presence of indelible ink, there have been multiple cases of impersonation, which shows that A, it is not necessary, and B, it is not suitable for achieving the purpose. The third test, Your Ladyship, is very important for the contemplation of this Honorable Court, which talks about the balancing of rights, Your Ladyship. The balancing of rights must be twofold. In this particular case, is twofold. Firstly, the right of the state to pursue a legitimate state action, and secondly, the right of the petitioner to perform their religious duty under Article 25. Firstly, Your Lordship, it is established that because it's not necessary and because it's not suitable, and in addition to the grave injury that is formed on the petitioner's right under Article 25, and on the flip side, the petitioner has a massive injury due to the fact that under moot clarification 10, as it was stated before, the ink does not go away for a period of few days to a few weeks. The grave disparity that exists between the right of the state as well as the right of the petitioner shows that balancing of rights was not properly considered. Your Ladyships, due to paucity, yes,
How do you interpret Article 25(2)?
25 clause 2.
Yes.
Your Lordship, if you could grant,
25 clause 2A specific.
yes, Your Lordship. Lordship, 25 clause 2A talks about regulation of any secular activity which is associated with religious practice. And this has been used in various Supreme Court judgments to mean that the secular activities of this religious institutions, for instance, tax collection or donations or things like that, which may be associated with religion but are secular in their nature. Your Lordship, that is what is contemplated under 25 clause 2, subsection A.
The restriction is any economic, financial, political, or other secular activities, right? So when the state is
Which may be associated with the religious practice.
Your Lordship,
So, Vudu, you say that it is a religious practice. You also say that you are not stopped from performing wudu. Is it your case that you have been stopped or deprived of performing this religious practice of wudu?
indeed, Your Lordship, it is
How?
Your Lordship, it's presented that the
You,
indelible
you,
ink.
you have not disclosed this, that how this religious practice you have stopped from
Yes, Your Lordship. The presentation.
performing this religious practice. And
Yes, Your Lordship. The mandatory marking of indelible ink onto the petitioner's finger presents a barrier between the permeability of water, which prevents a proper wudu from taking place, which prevents a proper salat from taking place. That is the link drawn.
is this stopping for a permanent period of time, or is it only for an intermittent period of time?
Your ladyship, while it is only from a few days to a full week, with namaz, which is being stopped, is an essential practice which has to be followed 5 times a day. Your ladyship, taking that into account, it's a grave injustice onto the rights of the offending.
So you say that tayyab is an alternative mode.
No, your lordship,
Then
that is not a case. Your lordship, tayammum is an alternative to wudu that is only under specific circumstances,
so
such as illness.
can this be put in a specific circumstance?
No, your lordship, there are very specific circumstances such as danger of life, danger of illness, unavailability of water. Only under these will it be allowed to perform tayammum.
So you mean to say the state doesn't have any power to make a law which will regulate uh, your religious practice, activities which is associated with the religious practice, an activity which is associated with the religious practice. There is a religious practice, there's an activity associated with that religious practice. Can't it be said that wudu is a religious practice and this activity of wudu, it can be restricted for some period of time?
Yes, your lordship, it is the submission that this restriction which is sought to be imposed must follow the test of public order, reasonable restrictions, which has not been followed. Also, under Article 13, Clause 2, any law which is made can't infringe fundamental rights, your lordship.
So, in addition to what Justice is asking you here, um, there are two aspects we're talking about: right to religion and right to essential practices. Is there a difference, or they are part and parcel of each other? That's number one. And second, when you were talking about the conflicting rights, um, let's also talk about the conflict between a customary practice and a constitutional provision and a statutory law.
All right. Your ladyship, answering the first question, which talks about a distinction between religious practice and an essential religious practice. This was drawn from Sardar Syed Singh as well as Tilayat Ji Maharaj, as well as in
I'll just give more clarification to my question. Can you correlate the concept of substantiveness and procedurality to these? You understand what is substantive and what is procedural?
Yes, your ladyship.
Yes. So, out of these two, right to religion and right to essential practice,
Yes, your
which
ladyship.
one would you classify under substantive and which one you would classify under procedural? And what is the correlation between substantive and procedure?
Your lordship, as per the council, substantive would relate to essential practice because it was held in Shaira Banu that authoritative text must be presented as to show the essentiality. So thereby, the courts must consideration all the text presented before it to show the substantiveness of the essentiality. Lordship, the other would be procedural, which would be just religious practice, which does not require the contemplation of this honorable court.
Right. The procedure is handmaid of justice. That's what we say. So you cannot tamper the substantive right, but procedure can be changed.
Yes.
That's the jurisprudence in law.
Yes, your
Right.
Lordship.
So over here, this is just a procedure, and that too, as Justice was trying to bring down your point to home, that this is only for a particular period of time. And when you're talking about exceptions, like when there is a danger, imminent danger, cannot the existence of law be calculated equivalent to that?
No, your ladyship, under the practice of wudu, it is stated that the most important is the intention to gain ritual purity.
Does it stop you from being in Islam by not performing certain rites or rituals for few days?
Yes, your ladyship.
Perform that rituals, you perform that ritual. So it is what is wudu?
Wudu is ritual purity gained by washing of the
Washing of hands.
Yes.
Now, how do you say where it says that the water should touch the skin?
Your lordship, in Al Bukhari as well as in interpretation of all four schools of fiqh jurists, has held that any barrier must be removed before performance of a valid wudu. Your ladyship, coming to your question, which states that
What do you mean by barrier?
your lordship, anything that prevents water from flowing over it and prevents permeability of the water from the substance.
So these are all interpretations of Quran.
Yes, your lord.
And is there a possibility that the Quranic interpretations may not be exact interpretation of Quranic tenets? Is there a possibility?
Yes, your ladyship, there are always exists a possibility. However, in this particular case, the four schools of fiqh jurisprudence agree upon this particular manner. All the four conflicting schools which originated in different parts of the world converge at this point, that there is an essentiality for wudu to have water flow over all parts of the body which are demarcated in a manner that there is permeability and there is attainment of ritual
What
purity.
is the purpose of this ritual?
Your ladyship, to
Is it purity of body, of mind?
Your ladyship, both. It is a spiritual practice as well as physical practice. Your ladyship, there must be attainment of spiritual purity in both of these senses, and thereby it is the intention of the petitioner which must include.
Is there a possibility that you may perform this ritual with impure mind?
No, your ladyship.
Is there a possibility that you may perform this ritual with mind?
No, your ladyship. In fact, it is stated that voodoo would be broken if there is an impure mind.
And how would you testify if there is an impurity in your mind?
Your ladyship, that is an individual uh, evaluation that
So there's no parameter to evaluate that.
your ladyship, it is the parameters are stated. However, because there's
And
no
still you would
authority.
continue performing. Still it won't be violation of your right.
No, your ladyship, if there is an impurity in your mind, then your ladyship, that your wudu would not be valid, and thereby your salah would not be valid. And if you practice it, that wouldn't constitute a
Please address the conflict of custom and a constitutional provision and a statutory provision.
Yes, your ladyship. Custom, as described in the Sabrimala judgment, states that anything that has material antiquity and historical antiquity and has the force of law in a particular region gains the status of custom.
What if the custom is contrary to the law, enacted law?
Yes, your ladyship, in the Sabrimala judgment itself, if a custom which is contrary to the law can be removed on the grounds of being under the constitution and having certain fundamentals.
Right. So does this custom of performing wudu go contradictory to the provisions of constitution as well as the people's representation?
No, your ladyship. In fact, it goes perfectly with the ideals of the constitution, as liberty of faith and the liberty of practice of the religion are one of the enshrined features in the preamble itself.
You are saying that there's no conflict.
No, your ladyship.
There's no conflict at
No,
all.
your ladyship.
So both can stay together.
Yes, your ladyship.
Then where's the dispute?
The
If both can
dispute
stay
is in the
together.
fact that performance of or the putting of indelible ink.
So we are trying to find out, there are two rights that we are talking about.
Yes, your ladyship.
One is your right, which is a constitutional right. There is another right, which is a statutory right. And now you are basing one right on the basis of your customary practices.
Yes, your ladyship.
Now we have to sit here and decide which one will prevail over the other.
Yes, your
So
ladyship.
is there a parameter for us to identify?
Yes, your ladyship. Your ladyship, the essential religious practices come in hand here, wherein it said that if a practice or a custom is essential to the religion, then it will be protected under Article 25, and no other religious practice will be protected under Article 25. And because it's been established that wudu is an ERP, that's why it will be protected under Article 25.
When there is a conflict between two rights,
Yes, your ladyship.
which right will get preference?
Your lordship, the right which is more engraved in the constitution. For instance, if there's a conflict between Article 21 and 25, it will be Article 21 which will prevail.
On what parameter you say that Article 21 will prevail over 25?
Your lordship, and Joseph, no, your lordship, the supremacy.
Is that a blanket rule or it will be subjective to
It
the
will
facts and circumstances?
Yes, your honorable lordships, it will absolutely be subject to the case by case basis. However, there are certain three rights which are essential, as called the golden triangle of rights in the constitution, which cannot be impeded by other rights. And there, according to Article 25, it places a proviso that it's subject to other rules of the Part 3 of the
Is there
constitution.
an exception to Article 21 too?
Yes,
Is there an exception to Article 21
due
also?
process of the law.
Correct. So isn't there a due process established by law?
Yes, your ladyship, it said that the due process itself must be within the restrictions, reasonable restrictions, which can be placed on the people. Due process of the law,
By whom? Reasonable restrictions by whom?
by the state, your ladyship.
By the state.
Yes, your
So there are reasonable restrictions which are put.
Your ladyship, these do not follow the test of reasonable restrictions, which fall under preservation of public order or the preservation of constitutional morality, or fulfill the test of proportionality. Would your ladyships like me to proceed to the prayer?
Time is already over.
We can present the prayer.
I can press the prayer. Yes.
Uh, Wherefore, in light of issues raised, arguments advanced, and authorities cited, it is most humbly and respectfully requested that this Honorable Supreme Court be pleased to adjudge and declare that the specially petition is maintainable under Article 136 of the Constitution, and that these elections relating to marking of electioning is violative of Article 25, and the violation of Article 25 does not fall within reasonable restrictions. And fourthly, that the petitioner is entitled to reasonable accommodation under the reasonable accommodation principle, and or pass any other order that it deems fit in the interest of justice, equity, and good conscience. And for this, the petitioner, as is duty bound, shall humbly pray. It was a pleasure arguing before this court.
Check, 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 check.
The counsel seek permission to approach the dais. Much obliged. Greetings to the honorable bench. The counsel seeks permission to address the bench as your honorable bench. Much obliged. The counsel stands before this honorable court on behalf of the respondents in the case of Dr. Dhulkifil Mohammad Naik versus Republic of Arcadia and the Election Commission. The counsel seeks permission from the honorable bench to provide them with the loose copies of the judgments and report as and when required. Much obliged. The first issue before this honorable court is whether the petition filed under Article 136 is maintainable or not. It is most humbly submitted before this honorable court that the said petition filed by the petitioners is not maintainable. To support this, the counsel would like to make two submissions. First, no exceptional circumstances exist, which involves substantial question of law as well as no gross injustice has been done to the petitioner. Second submission would be an alternate remedy is already available with the petitioners, which they could have availed. Proceeding with the first submission, the counsel would like to draw the attention of your honorable bench to the case of Jamshed Hormuzji Wadia versus Board of Trustees, wherein the court held that, I quote, this court observed that the discretionary power of the Supreme Court is plenary in the nature, in the sense that there are no words in Article 136 itself qualifying that power. The power is permitted to be invoked not in a routine fashion, but in very exceptional circumstances, as when a question of law of general public importance arises or a decision sought to be impunged before the Supreme Court shocks the conscience. Honorable bench, in the present case, the violation of Article 25, which the petitioner are contending, is not absolute in itself. It has three exceptions to it: public order, morality, and health. And these sections, which they are asking to be struck down, essentially deals to safeguard the impersonation in the society. If those specific section would be struck down, then it will lead to the impersonation society, which is a criminal offense under the IPC section 171D, which will eventually disrupt the public order in the society. Proceeding to the second submission, your honorable bench, the indelible ink is the one of the most sufficient method available right now. Not just in India, as per the reports of by the International Foundation for Electoral System and United Nations Development Program, more than 90 countries have used indelible ink as a way to ensure that voters cannot cast multiple votes, which itself shows that more than 50 countries are using indelible ink, and it establishes the efficiency of the ink. Even UNDP is funding a program where they are checking the indelible ink, how it can be supplied to most of the countries. Coming to the second submission, that an alternate remedy is available with the petitioners. The council would like to draw the attention of your honorable bench
to the case of Nirma Limited versus Lergy Lentigis Energy Technique GmbH, wherein the court opined that the aggrieved party must exhaust any remedy which may be available under the law before lower appellate authority or high court. To support this, the council would like to draw the attention of your honorable bench to the Supreme Court Rules 2013, Order 21, Rule 3, Clause 5, wherein it has been clearly stated that the party who's approaching the court under special leave appeal has to show whether they have availed the remedy of latest patent appeal or writ petition, or whether the said remedy was available to them. If we see the moot proposition and the moot clarification, it is clear that no other remedy has been availed by the petitioners.
Counsel, would you also interpret Rule 4 in Supreme Court rule? The paragraph that you read, whether a letter patent appeal or a writ appeal lies against. So, just a paragraph before that, 4.
4.
Yes.
Your Honorable Bench, 4 deals that the party who's approaching under special leave has to disclose full name and address of the parties that were in the conflict in the case. And in the
I will read it for you. It says, the petition shall also contain a statement as to whether the matter was contested in the court appealed from, and if so, the full name. Whether
Indeed.
the matter. Disclosure of name and address is not the substance of this provision. The substance of the provision is whether the matter was contested in the court appealed from. In the present case, we believe that there was a matter which was contested and we have a discretion to decide.
Indeed, Your Honorable Bench, the court has the discretion to decide. However, a proper procedure needs to be followed. But
You have taken a plea that there is an alternative remedy, so this application should be dismissed. Once you take a plea, the burden of proof is upon you to establish that there is an alternative remedy. Have you stated that these are the alternative remedies which they have not taken? They have not availed of. So this is not maintainable.
Your Honorable Bench, I would like to draw the attention of your bench to the moot clarification question number 40, wherein it has been stated that the petitioner has not approached the division bench of the
16. Question number 14.
14.
In clarification.
Clarification
indeed.
16. After dismissal of the writ petition by so and so from the High Court, did the petitioner go to any other bench?
Indeed, Your
Then
Honor.
16. It
16.
says no.
It's no.
It says no. The question is the clarification whether there was any latest patent jurisdiction available to that court.
Indeed, Your Honorable Bench, I would like to draw your attention to the case of Union Territory of Ladakh and others versus Jammu and Kashmir National Conference and others, wherein first a writ petition was filed under Article 226, then a latest petition.
Is latest patent applicable throughout all the high courts? All the high courts have adopted latest patent.
As per the knowledge available to the council, most of the high courts have the later patent appeal.
That means you say not all. Suppose this high court doesn't have a latest patent jurisdiction, where will this petitioner go?
Your Honorable Bench, the fact is silent on whether this Honorable Court has the later patent appeal or not. However, as per the case, as per the procedure, after 226, a later patent appeal can be filed, as I just mentioned, the case of Union Territory of Ladakh. And after that, only the Supreme Court accepted the special leave under Article 136 in that particular case.
Suppose there is no latest patent appeal jurisdiction. There is no latest patent appellate jurisdiction. Then what will happen? What is the remedy?
Your Honorable Bench, an appeal to the division bench is available with the petitioner.
Under which provisions? There is no latest patent appellate jurisdiction in a particular high court. So a writ petition is filed under Article 226. It's get dismissed or allowed. Now where will that aggrieved party go? The party cannot be remediless.
Your Honorable Bench, firstly, there is no exceptional circumstances. There is no substantial question of.
See, the question is whether it is maintainable or not. If the case is not maintainable, it will be thrashed out at the very initial stage.
Indeed.
Now, if it is maintainable, then your second question comes whether to accept their proposition or not and whether to throw out.
Indeed.
First, you have to because since it is your objection, your preliminary objection, You are taking a preliminary objection on the point of maintainability. So you have to prove that it is not maintainable on these grounds. So I am putting you a question. If particular High Court doesn't adopt the latest patents, it is from the charter.
Indeed.
Now, if the High Court doesn't adopt that, then what is the remedy?
I'm going to leave the parties without any recourse.
Sorry, Your Ladyship.
In such scenario, I will leave the parties without any recourse.
Whether the party will go remediless or 136 is the appropriate remedy before that. If there is no latest patentable, this is a question to
Your Honorable Bench, Article 136 is not a right to appeal. It has to be the last recourse of the petitioners.
Isn't this scenario a last recourse? For the petition.
taking a situation where there is no latest patent appellate jurisdiction.
I just seek 10 seconds from the Honorable Bench. Your Honorable Bench, in case latest patent appeal is not available, still the petitioner can file a appeal before the division bench of the same High Court.
Under what provision?
The council just seek.
That's it. Forget about the pen.
The council seek just 10 seconds from the Honorable Bench.
Where do you derive this concept of appeal and the right to?
Your Honorable Bench, right to appeal is when the party is aggrieved by the judgment, degree, or order passed by the lower court.
Who gives you the right to? Who gives you? A statutory saying your what right? Or it is a statutory right or a constitution?
Your Honorable Bench, the right to appeal is also granted under the Constitution, that is Article 132, wherein in 132 to 134, wherein any judgment, degree, or order can be appealed before this Supreme Court.
So as per you, the right to appeal should be there in the statute or the law.
Your Honorable Bench, the appeal to the division bench, the council is not provision. However, it is there in the CPC. I seek apologies for not knowing the exact provision.
Okay, continue. Proceed with your next.
Henceforth, it is most humbly submitted to this honorable court that an appeal is available with the petitioner, which they can avail of. And as I mentioned before, that no exceptional circumstances exist in the present petitioner. Henceforth, the said petition should not be held maintainable.
So I'm putting you the same question which I had put to them. If there are conflicting two rights, if there are two rights, I'll not say it's even if it's conflictive, which right will have to make a way?
Your Honorable Bench, it depends upon the circumstances and facts of.
There's an Article 25.
Indeed.
And the right to vote.
Indeed.
So now, if this in the background of this, your facts, which right will have to make way for that?
Your Honorable Bench, as I said, Article 25 is not absolute in itself. It has certain reasonable restriction. Free and fair election, which is also a part of basic structure, as held in the case of Keshwananda Bharati versus State of Kerala. And herein, the state is trying to.
Not comprehended Honorable Justice's question. His very specific question is the rights when they conflict, on what basis you are going to claim those rights. So you talked about limitation in one right. Do the rest of the two rights also have limitation? And how do you then resolve that conflict?
Your Honorable Bench, if fundamental rights are in question, then the fundamental rights will prevail. However, herein, right to vote is a statutory right, as held in the case of People Union Civil Liberties. So the statutory rights are limited to the statutory limitations. Herein, they should have also filed an election under under Representation of People's Act Section 80A.
What does it say?
Section 80 says that the High Court has the power to try the election petition.
What is an election petition?
The grounds for the election petition are mentioned in the Section 100 of the Representation of People's Act, wherein it has been said that subject to the provision clause D, fourth point, wherein by any non-compliance with the provisions of the Constitution or of this Act or of any rules or order made under this Act. So an election petition could have been filed in the present case.
Counsel, can you explain what is an election petition? Has it been defined in the Act?
Your Honorable Bench, election petition is whenever any election process is in the question. Now, election process has been defined by the Honorable Court, wherein Section 14 to Section 66 of the Representation of People Act can be called in the question. And in the present case, Section 61 Clause A of Representation of People Act is also in question, and it also deals with the marking of indelible ink. Due to paucity of time, the counsel would like to summarize this issue, and the rest of the merits will be dealt by my co-counsel. Henceforth, the counsel for the respondent humbly pleads before this honorable court that as the alternate remedies available with them and no substantial question of law exists and no gross injustice has been done to the petitioner, the said petition should not be held maintainable. If your honorable bench is well satisfied with the arguments, my co-counsel will proceed with the second issue. Much obliged.
Your lordships and your ladyship are satisfied with the arguments of my co-counsel, the counsel would like to move to issue number 2 and present their arguments. Very well indeed, your lordship. I'll try to satisfy if I complete my arguments of second issue within the time frame. So the second issue before this honorable court is whether 61A of Representation of People's Act, read with Rule 37 and 49K of Conduct of Election Rule, is violative of Article 25 or not. Article 25 itself has two codes within itself. One is prohibitory part and one is affirmative part. And what the Supreme Court as well as the court does is to strike a balance between positive code and negative code by applying doctrine of essential religious practice. So it was held in the case of Ghulam Abbas versus State of Uttar Pradesh that the exercise of fundamental right under 25 and 26 is not absolute and yield to give maintenance to the public order. Also, in the case of TMA Foundation versus State of Karnataka, 11 judges bench held that the opening words of Article 25(1) makes this right subject to public order, morality, and health, and also other provisions of Part 3 of the Constitution curtailed or regulated if exercise of that right would violate provisions of Part 3 of the Constitution or exercise thereof will violate public order, morality, or health. And therefore, two broader submission the council would like to submit. Number one, that voodoo is not an essential religious practice because it does not pass the test of essential religious practice. Number two, that if it passes the essential religious practice, the practice is in violation to public order, state can regularize it. And that has been affirmed by 11 judges bench in the case of TMA Foundation versus TMA Pi Foundation versus Taka. Coming up to my first submission, that voodoo is not an essential religious practice and does not pass the test of essential religious practice. So there are majorly two tests which needs to be applied in the essential religious practice test. Number one is test of nature of impact and practice, as it has been directly fallen from the honorable bench in the petitioner's case, that police versus Acharya Jagdishwara Audhata. So voodoo, the object of voodoo is purification. Quran itself says purification. However, In nowhere in the Quran word voodoo is used. Also, the verse has ambiguous interpretation, and the verse itself says two modes of purification. Number one is by water, number second is by sand. And no grounds of invalidation of wudu has been postulated in Quran. All the inferences of fiqh jurist, hadith has been drawn, and it is put up in the procedure. But Quran being the primary source and being the holy book of Islam, in the Quran, in none of its words says that if you don't perform wudu, you would not be called as a believer of Islam, or if you don't perform wudu, you would be ousted from Islam, or if you don't perform wudu, your salah won't be accepted. So, therefore, practice of wudu is dehorsed from the test of nature of practice and its impact. And the second and most important test is test of scriptures. As I have cited earlier, that Quran has ambiguous interpretation. The petitioner is relying on hadith. We would like to submit one hadith in loose compilation, which is the highest form of hadith, that is Sahih Muslim hadith. Kindly come to page page number 7 of the hadith, which says hadith are compiled actions of Prophet Muhammad. So Prophet Muhammad performed wudu after urination and by wearing a shoes, and he wiped sands. So if layer of shoes is permissible and that has been affirmed by Prophet Muhammad, why allegedly the ink of indelible ink, which is meant to corrupt personation and which is allegedly creates a layer. However, there is no report filed by the government. The formula is patented. These are the contention based on the mere assumption. Only one composition is revealed, that too of silver nitrate. Other than that, no revelation is there on the part of the government that composition of indelible ink is such that it creates a layer. So these are the ambiguities within the hadith. Hadith also does not have a proper interpretation. Therefore, it is hadiths are immaterial to be relied upon. Also, secondly, everything written in the Quran is not termed to be as an essential religious practice, and this is affirmed by this honorable court. Slaughtering of cow has been affirmed and has been affirmed in Quran, wherein Prophet Muhammad himself command that you have to slaughter an heifer. Heifer is a synonym of cow in Surah number 2, verse number 67 to 73. However, this honorable court in the case of Muhammad Arif Qureshi versus State of Bihar said that it is not an essential religious practice, because slaughtering of cow can never be essential religious practice of any religion. So therefore, on the ground of this two main test, wudu is dehorsed from the test of essentiality. Coming to my second submission, that is power of the state to regularize uh, this essential religious practices, especially when are s- representative statutes are subjudiced before this honorable court. So it is believed that election is a festival of democracy, and Sir Winston Churchill, father of democracy, has nicely quoted that at the bottom of all tributes paid to the democracy, a little man walking into a little booth with a little pencil, making a little cross, little bit of paper, no amount of rhetoric or voluminous discussion can possibly diminish the overwhelming importance of that point. So it cannot be anybody's case that representative statute should should give us the remedy of certain caste of people, because poll doesn't discriminate on the basis of caste, creed, and religion. Poll has to be neutral. So no exception on the ground of religion has to be granted, especially in the poll, which directly goes to the edifice of democracy. And the object of rule and section 61A is to curb personation. Personation is criminal offense, and which is against the state. And the election notification of 2024 election has came yesterday at 3 p.m., wherein the election phase has started. Now, no alteration can be made in election process due to this reason, because if these sections have been struck down, there are high probability that personation will increase, and the common man's interest would be defeated, because the right of choosing representative would not be would decimate the purpose of free and fair election.
Counsel, regarding your argument of essential function, the test that you have cited, which Supreme Court has used and has laid down. My question here is, when you talk about essential religious functions, who has the authority to decide what essential religious functions are?
The honorable court. has the authority to decide.
Is it the court or is it the community who is following that religion for ages together? They will decide what are essential religious functions.
Two answers
The
to
court will decide and comment upon the validity, reasonability, and constitutionality. But what is essential religious function? Who has the authority?
at the end. Affirmed by N. Adityanan versus Devasum Travancore Board, the court has the authority. We would like to present the judgment to the bench. So, but
My question, I hope counsel is clear to you.
mm,
I'm not asking whether the court has authority to strike down the reasonableness or validity. My question is, who will decide what is an essential religious function?
religion would decide, but that religion belief has to
Is
be
it religion or is it the community who's following that religion? What is ultimately religion? Can you explain? Because we are arguing here both the sides on the very important issue and none of you are touching on that. How do you define and how do you explain what is a religion?
religion is religion is a matter of religion is a matter of faith, and uh, religion means religion differs from person to person, and religion has to be interpreted as per the conscience of an individual.
So though it differs from person to person, there has to be a alignment and consensus of that community. Then only it will classify as a religion. If I alone am following something, it will not be. Right? So the whole purpose of religion is community. And it is the community who will decide what is an essential facet of their religion, isn't it?
uh, for a moment, I am not denying that community will decide, but just the decision of the community would not render the state to strike down these rules. The decision of the community is that whether practice is an essential or not has to be affirmed by this honorable court. If this honorable court affirms that the belief of the community is right and it is falling under the test of essential religious practice, then state has then this honorable court has the power to decide essential religious practice is there or not.
So coming to your the secular aspect of it, let's talk about it. Do not the state have alternative ways of ensuring that there is no fraudulent practices or impersonations that are happening in the process?
Currently, state doesn't have any alternative remedy, and impersonation might be there. But if striking down of this section would create an irreversible consequences, and that
What irreversible consequences do you contemplate here?
consequences would be that striking down this section for a 14% of people will disseminate the interest of rest of the 86% of the people, because they won't be allowed to choose their
So the
representative.
test of religion, is it about the number or the quantity in the minority, or is it something else?
No, no. I am not saying that practice of essential religious practice should be determined on the basis of majority or minority, but representative statutes are to be interpreted in the case of majority or minority, because the people of the state as a whole is getting affected by representative statutes.
So isn't it the responsibility of the state to uphold everybody's rights when they are creating legislations? There's a very strong presumption that the legislations are constitutional and they are not in derogation of fundamental rights. That casts a big responsibility on the shoulders of the legislators. So while they are drafting the legislation, shouldn't they have been mindful about, you know, accepting, acknowledging, and appreciating everybody's rights?
Indeed, it is an obligation on the state to enforce everybody's fundamental right. And while drafting the legislature, state has to consider. But this petition is one of its own kind. Till date, indelible ink is used since 1960. 90 countries are using this indelible ink. Some of them are Muslim majority countries, and no such kind of petition has been filed. And
Council, is there any research that the government is conducting on finding out if it is not on the skin, some other place where the ink can be used?
government is currently going on with the project of applying an UV rays, but it will certainly take time, because research on phases research has to be conducted, and first phase of the research has been conducted, whereby in Kashmir and Nakshal areas UV ink has been applied. And
Can there be any specific provision created specifically for a community while performing this process of ballot?
no, in representative statutes cannot be created, because what makes the
Is there
state
a discretion that the authorities have, the election authorities, election commissioner or election authorities have?
No, election authorities alone cannot have it. With state in consultation with election commission have it. It has been there in section 169 of Representation of People's Act. that rules are to be made in consultation with state government and election commission parallelly.
I am putting you the same question, which I put to everyone.
Hmm.
When there is a conflicting rights,
Hmm.
how do you balance it?
If there is a conflicting right, fundamental right will prevail. There is no doubt about it. But statutory rights are subject to statutory limitation, and you cannot circumvent the proceedings to, to exercise that statutory right by comparing it with a fundamental right. Article
Counsel, here the conflict is between two fundamental rights.
right to
If
vote
there
is
is a fundamental right and a constitution, a statutory right, then of course your statement warrants that it's the fundamental right. Here we are talking about right to vote, which is essentially an aspect of a fundamental right. And on the other hand, we are talking about right to religion. How do you reconcile that?
indeed your ladyship. However, as per the knowledge of the council, right to vote is a statutory right affirmed by this honorable court, 5 judges bench under People's Union of Civil Liberties versus Union of India. Council seeks extension of time subject to the
So just because a particular right is a statutory right, does it stop from being a fundamental right? Can it not be interpreted under the freedoms
but,
of speech and expression?
uh, it is the dissenting opinion of Justice Chandrachud, but until and unless it is incorporated in statute, the evolution of law and position remains the same. That right.
Fundamental rights, do they have to wait for the declaration of the statutes or the constitution? Fundamental rights are inherent. Though they are guaranteed by constitution, this has also the jurisprudence that has been evolved by the courts. They are not creation merely of law. They are not merely creation of constitution. There are certain rights which are inherent. They would exist irrespective of whether the constitution exists or not.
But fundamental rights are not absolute rights. There are quality.
And the right,
Hmm.
and the right which you exercise uphold the basic structure of the constitution.
So basic structure here here statutory right also goes to the basic structure of the constitution, because free and fair election are the part of basic structure as affirmed in Keshwananda Bharti versus state of Kerala. So therefore that is what the case is, that merely on the basis of allegation, and especially when elections are on hand, statutes cannot be amended by a mere allegation, and you cannot circumvent the proceedings in a manner in which statutory right has to be exercised by making it reference with the fundamental right. And these are not my words, these are the words of this honorable court in the case of Ankul Chandra Pradhan.
Council, we are contemplating here now a futuristic, because whatever we will be deciding, it's going to have a prospective application. So we are not contesting about the capacity of amending the provisions during the election process. We are now talking about what is the further course of action. So now we have to decide whether this is a valid provision. If we come to conclusion and if you are able to convince us, we will have to strike it down. If you're able to convince it's constitutional, we'll uphold it as a constitutional, and that will be applicable prospectively.
Indeed, your ladyship, it is in adherence with the provisions of the constitution, because till as I have argued on factually that till date no such petition has been filed. The formula has not yet been revealed by the government on what basis the petitioner has filed the petition, that it creates a layer on the ink, because our skin consists of three layers. One is epidermis, dermis, and hypodermis. This indelible ink is applied on the upper epidermis of the layer, and epidermis allows water to penetrate inside it. So how come this petition has been filed? Because no material is there on record to take an inference that indelible ink creates a layer. And if it is so, Hadith says that Muhammad has worn the shoes and performed the wudu.
The question on the point of maintainability.
Very well.
You say that your team say that the 136 is not maintainable.
It can be converted subject to your Lord's discretion. Sabrimala case was also been converted to writ petition, but that is not the prayer of the petitioner. So
is it necessary that petitioner should pray for it?
But this is the respectful submission I am making before this honorable court. Ultimately, I leave it to your lordship because it is the discretionary power of the honorable bench.
So what does 32 say?
Article 32 says that when your fundamental right has been infringed, you can file writ petition for enforcement of the fundamental right.
Now, I put a next question. So if you say 32 is maintainable, now we have a judgment and the issues have been already been decided by the court. Now will it not be hit by res judicata?
It will hit by the res judicata. Daira versus State of Uttar Pradesh. Daira versus State of Uttar Pradesh clearly emphasizes that if you have approached under 226, you cannot approach under 32. But however, there has been instances that res judicata has been sidelined because it is a procedural aspect, and procedural aspects are not meant to vitiate the right, especially fundamental right. So that's why I said that it is the discretion of the honorable bench, and I am leaving it to the honorable bench whether it deems fit to the honorable bench. And coming up to election petition, I have to satisfy my lords on election petition. Very well. I'll summarize it within 30 seconds. Election petition is maintainable because election matters are tried under High Court. And Section 100 of Representation of People's Act very well says that if election is not in consonance with provision of the Constitution, you can file an election petition. That is their allegation, that election is infraction of our fundamental right. So it means that election is not in consonance with uh, uh, provisions of the Constitution, so they can file that election petition under that ground, and that would be the more efficacious remedy, because under election petition his statutory right can be enforced by making a repoll, and his fundamental right can also be enforced because High Court has jurisdiction to direct the election commission to amend that rules. But however, um, it is the inference that abuse of process has been made because no election petition has been filed, no LP has been filed, no appeal from order has been filed. Directly 136, which is the last recourse, has been filed before this honorable court. Indeed, the honorable bench, it was a pleasure arguing before this honorable court. And the council would like to move to the prayer. In the light of the facts stated, arguments advanced, and authorities cited, it is most humbly prayed that to dismiss the present petition and to pass any order that the honorable court may deem fit in the favor of the respondent to meet ends of justice, equity, and good conscience.
Your Lordships, coming to the first point of the Council for Respondents, wherein they argue that an alternate remedy for the petitioners exists in the form of a letter patent appeal, the Council for Petitioners would like to highlight the fact that LPA refers to when a petition goes from a smaller bench to a higher bench. It is a mere superficial assumption on the part of the Council for Respondents that under this factual matrix, the highest bench was not dealing with the judgment in the High Court judicature of Jason, your lordships. And even if this court of law assumes that LPA exists, the Council for Respondents in the page 12 of their memo used the case of SG Dice to establish their case, wherein upon the Council for Petitioners research in the factual matrix of the case itself, the petitioner was allowed to move to the Supreme Court under Article 136 without availing the remedy available under Article 226 and Article 227, your lordships. Coming to the
Me to say that there is no absolute bar in invoking the alternative jurisdiction.
yes, your lordship.
So what is the nature of bar?
Could you repeat the question?
What is
Your
the
Lordship?
nature of bar?
Your Lordship, the counsel for petitioner here argues that uh, the factual matrix is silent upon what was the bench strength for the case that was dealt in the High Court. So the counsel for respondents cannot merely assume that it was a single judge bench that was dealing with the case in the High Court. And even if they do assume that the case that they rely upon, that the SG Dice case itself allowed for the petitioner to move to the Honorable High Court under Article 136 without availing the remedy available under Article 226 or 227 of the Constitution. Your Lordship, the Council is not aware of the factual matrix upon the ground for which they were allowed. Your Lordship, it was because it was a discretionary power of the Supreme Court to allow the petition or not. It was allowed under Article 136, Your Lordship. Coming to the point of how the respondents say that the counsel for petitioners can file an election petition upon a bare reading of Article 329, clause B of the Constitution, it says that the election petition refers for the procedure for challenging the result of the elections, Your Lordship. In this particular case, we're not challenging the result of the election, we're challenging the rules itself, which violate the petitioner's fundamental right under Article 25, Your Lordships. Further, the respondents make the point of how the wudu was performed by Prophet even while wearing socks, Your Lordship. That is completely baseless, Your Lordship, considering the Prophet himself in this particular source said that the foot must be cleaned before putting in socks, and wudu or purity must be attained. In any case, wudu must be there, and it cannot be conceded that just because the Prophet wore socks, wudu was not performed properly, Your Lordship.
Council would like to seek permission to approach the podium.
Not done. Not done.
Okay. Very well.
Coming to the point of how the respondents say that the cow slaughter in that particular case was established to not be an essential religious practice, Your Lordship. According to the source of Surah Al-Baqarah, it is held that anything can be sacrificed. It does not has to be essentially a cow. It could be a buffalo or a goat itself. The idea is heifer does not refer to cows only. Therefore, the ground for which it was not established to be an essential religious practice was that the presence of a cow is not essential, not the fact that the practice in itself was not essential or not, Your Lordships.
Council seeks permission to.
Yes, Your Lordship.
Rebutting to the first contention of my learned friend that LP lies and LP has been allowed. 136 is the discretionary power. We have just shown to the honorable bench that LP lies, whether then, and that would be the subject matter of this honorable bit, whether to render petition maintainable or not. Number two, that they are not challenging election, and they are challenging election rules. That is the result of clever drafting and twisting the words, because this honorable court, in the case of Election Commission of India versus Ashok Kumar, says that the word election in 329 has to be interpreted in broader sense, which includes from notification under section 40 to section 66 of the act, and they are challenging 61 of the act. So how come they don't fall under the nomenclature of the election? And as I have shown it to my lordship, one of the ground of election petition is election is not in consonance with the provision of the constitution, and their case is that infraction of fundamental right has been there. So it ipso facto says that election is not in consonance of the provisions of part 3 of the constitution. So both the grounds are satisfied. So this is the result of clever drafting and twisting of words. Number 3, that's all. And now some of the latches which I would want to highlight from the side of the petitioner. The honorable bench may kindly refer to the cause title, first page of the petition memo of the petitioner. Dr. Dhulfikul Ahmad Nayak versus Republic of Arcadia. Moot preposition clearly says that others, election commission has not been made as a party. In order to give direction, election commission has to be mandatorily be made as a party. Otherwise, it would be a non-joinder of the necessary parties. Secondly, they are under the appellate jurisdiction.
Ground of non-gender of necessary parties, can the petition be thrown out?
No, petition cannot be thrown out. These are some of the latches which I am highlighting before this honorable court.
Does it affect?
Affect the merit of the case.
Uh, it is a
So, Order 1, Rule 10 can be applied.
Supreme Court rules order 21, blue highlighted part, rule number 4, which actually the honorable bench has asked the question to my learned friend. That was the provision highlighted for this particular rebuttal. That Supreme Court rules makes it mandatory that you have to attach all contesting party before the High Court. Number 2, they are before the appellate jurisdiction. And kindly look at the prayer clause. No prayer has been made to struck down the impugned order of the High Court.
Don't you think the prayer can be molded at any point of time?
Prayer can be molded, but an amendment in the prayer should not be made in such a way that the whole merits of the petition can be altered, and they are standing before the highest court of law. At least this kind of laches must not be accepted.
Not talking about the latches of the petitioner. If it is not prayed, does it preclude the bench from passing an order which is not prayed for?
No. For a moment, I am not questioning the discretionary power of this honorable bench in any of my contention. Number 3, that there has been a misrepresentation 2 times before this honorable court. Kindly come to page number 5 of the petition memo. They have cited a verse, but verse is incomplete. Para number 18. When you raise to pray, wash your face. So they are interpreting the instrument, especially religious instrument, in isolated form.
How it is, what did you say?
When italic one, when you raise to pray, wash your face up to your hands and elbows. When you are citing a religious instrument, the whole verse has to be cited. And secondly, that right to vote is a constitutional right. It is the settled proposition by 5 judges bench. In the pleadings, they have stated that it is a constitutional right, but it is not. It is a statutory right. Quran, I may provide it to your lordship. The whole verse is very long. And Haifer, this is the copy, translated copy of the Quran that has been used in Shaira Bano case by Abdullah Yusuf Ali. And verse 67 makes it mandatory that it is the command of the Prophet to sacrifice the heifer. And that this rationale has been drawn in Muhammad Hanif Qureshi. So this is the third misrepresentation before this honorable court. Indeed, the honorable bench, it was a pleasure arguing before this honorable court.
Proceedings are over.
I request everyone to please rise for the national anthem. Oh my God. You're taking a laptop, right? Yes. So, starting off, I would like to invite upon stage our respected head of department, Dr. Anto Sebastian, to address the gathering.
Good afternoon, all. Our beloved Chief Guest, Justice Anandasan, Guest of Honor, Professor Swati, Director and Dean, Dr. Lijo Thomas, Academic Coordinator, Father Justin Verghese, my dear colleagues, as well as the participants and students. Today, it has come the last final for the validated THEMIS, and I'm not stretching anything because all of you are hungry. So I don't want to stretch anything. Only one thing I want to tell you, that is mooting is an essential thing for the students to become a lawyer, and the ability that you have to inculcate is persuasive advocacy. The art of persuasive advocacy is the most important quality that you can gain through moot court. So try to attain that and to be a great lawyers of tomorrow. Thank you. Thank you.
Thank you, sir, for your kind words. Let us all take a moment to honor the presence of our distinguished judges, Honorable Justice Ananda Sen and Dr. Swati Yogesh, who have taken out time from their busy schedule to judge today's final. Honorable Justice Ananda Sen completed his LLB from Chota Nagpur Law College, Ranchi. After obtaining his law degree, he practiced at the District High Court of Chaibasa and Saraikela, Karsava. He shifted to Ranchi on October 1997. and started practicing in the High Court of Jharkhand under the able guidance of late M.M. Banerjee, who was also the first Advocate General of the state of Jharkhand. He started his independent practice and continued the same till his elevation as an additional judge at the Jharkhand High Court. Sir predominantly handles constitutional, civil, criminal, labor, and service matters. He became a permanent judge of the High Court of Jharkhand at Ranchi on January 9th, 2018. Sir, we cordially welcome you. Dr. Swati Yogesh is an academician and alumni of ILS Law College Pune. She had she holds experience of more than 15 years in teaching and academic administration. She has joined her alma mater after serving in various institutes in capacities like head of department, principal in charge, and vice principal, assistant professor in School of Law in Christ University, Bangalore, and Symbiosis Law School, Pune. Published several research papers in various national and international journals, more than 6 reading materials for law schools and government institutions. Ma'am has also participated in many conferences and seminars. Ma'am, we welcome you. I would now like to invite our Dean and Director, Dr. Father Lijo Thomas, the to honor the guests.
I would also like to take this opportunity to say a few words of appreciation to the entire organizers, and in a very special way, our Honorable Justice Anand Sen and Ms. Swati Yokesh, and all the other, even judges who spent their 2 days over our campus and made this event a grand success, and all the participants and dear student organizers for your commitment and hard work. And it's all because of your lot of commitment and hard work and lot of people's generosity is what we are actually celebrating. And we all have received a lot of generous people who taught us, who shared their own time beyond their um, the 95 or 94 work hours. That's what we are, a product of all those things. And Justice Anand Sen was just talking about me how his mentor was working, and it's all really heartening to see that we are all product of a lot of people's generosity. One single word: just be grateful for everybody and for the universe, to the country, and commit ourselves for the country and for the justice and order which stands that word, THEMIS. Thank you.
I would like to request the judges upon the stage for the felicitation. Now, I would like to invite our esteemed judges onto the podium to share their remarks regarding the final round.
Good afternoon, all of you. You all were wonderful, remarkable. Frankly speaking, I didn't expect uh, this your argument at this highest level, and it will be not an understatement if I say so that even many of the high courts, the lawyers don't argue as you all have argued. Your preparations, your preparations were beautiful. The way you countered our questions and you gave your replies was remarkable. And I hope you all will live up to this and keep this effort which you have all put in.
Good afternoon, everyone. Um, Thank you, Anto sir, Chetan, Father, Lizzo, my students and now my colleagues, all of you for inviting me here. Coming back to Christ is like coming back home. And I'm very happy that Christ Lavasa has started this initiative of conducting moot court competition. So friends, as all of you might know, this is not about winning or losing. It's a learning experience, and I'm sure everybody has taken home something from this activity. Just few feedbacks about both the parties, as very rightly pointed out. You had come really well prepared, and we were very happy to see the kind of arguments that you had presented, the kind of preparation that you had shown. Um, I'm sure we cannot stop being complacent with that. There is further more to do, but then this is a very nice beginning. It's a very good, humble beginning. There are areas of improvement, no doubt about it, but then looking at the years that you come from, it's your learning stage, and looking at that proportionately, your performance was really good. Just remember, whenever we argue any dispute, it might be a legal problem, it might be a dispute which is before the court or otherwise, remember that it's always a dispute on right. And whenever you talk about a right, it's very important that you first understand what is the nature of right. Second, understand in what is that right rooted. Is it rooted in legislation? Is it rooted in constitution? Is it rooted somewhere else? Probably custom or probably somewhere else. Once you have a very good clarity, then comes which right is conflicting where. And Honorable Justice kept on asking every point of time, where is the conflict or what, how, which right conflicts with what, and how do we decide which conflict should be, so probably you are not going to find answers always in a constitution, always in statutes. There'll be definitely answers that will be found in jurisprudential argument. So find out if there is no legislation, if there is no precedent, if there is no rule, no regulation, then we definitely have some argument in jurisprudence. So beyond whatever citations you have in the form of international law or theorist, jurist writing and authoring books, try and understand, because the conflict, Roscoe Pound's theory of how do you balance the conflicting interests when both the interests fall in same plane. When when it is one fundamental right, one statutory, very easy, it's a fundamental right that will prevail. But what if two fundamental rights are contradicting with each other? So the answer definitely within fundamental rights, what will be the level of? So whether one is a right which is a social right, whether it's a public right, whether it's an individual right. So we would expect through this activity that it's a learning scenario, it's a learning activity. And so I would request all of you to not be mindful only about hard law, also the soft law. So ultimately, what you are going to become, future judges, future lawyers, future executives, it's going to be your good understanding of the legislation, the hard law, and the soft law, that is in the form of jurisprudence or the other theories that we have. It was pleasure judging all of you and pleasure being here in Christ. Thank you all and wish you all the best for your future endeavors.
Uh, Good afternoon, everyone. I hope you had good 3 days of a lot of mooting, a lot of lessons to learn. And when we talk about lessons to learn, I have with me my guru. I started my career as a graduate under him. I was a law researcher under him for 2 years, and he guided me for various aspects. So I like to invite Lordship to address the students as to what is law, how you should love this profession, how you should profess the profession, and Lordship can interact with you.
Again, good afternoon to you all. I'll say good afternoon to my uh, to all our fellow students. I also consider myself a student. The day you enter the profession and you think that I'll be a lawyer, you are a student till the last breath. Be a judge, be a lawyer, be in corporate, wherever you are learning, you are in this learning process. As a judge, I would say that if I say that I know every law, I know everything, I am I am the biggest fool standing before you. The lawyers, as a lawyer, they educate us on many aspects, on many laws. See now what happens. The three basics law of our country is now changed. With you, I have also to go back to school to learn what is it. So it's a continuous process which you have to be. So you have to adapt yourself with in respect of all the situations which you face. Because now I think you all are in a very comfort zone. After 5 years, after 3 years, when you go out of the college, your law school, you will be in a world where comfort is the last word. If you want comfort, you have to toil, you have to work hard for long years, then ultimately you can achieve comfort in your life. For that, as I said, that you have to work hard. First, work hard means you have to read and then put questions. First of all, as a student of law, you have to question yourself. You read a line and they say, why this line is written in this manner? Why not in the other manner which it could have been? Why this word is used in a statute? Why not the alternative other word which could have been used? Because in a statute, every word has a meaning and relevance and significance. And then you have to see that this particular line which you are reading, particular word which you are reading, on what context it has been said by the framers of the law. It is very important. In a particular statute, it may have a different context. In another statute, it may have absolutely a different context. So you have to put questions to yourself and then to your peers and seniors. Now, the second aspect is once you go out of your school, before that, you have to decide that where you want to be. In our days, I say 25, 30 years, the law for a student was the last option because there was engineering, there was medicine, which was the most sought after profession or vocation those days. Today, also, I can't deny that medicine and engineering is the most sought after. But you see the comparative chart, and if you see the opening, which a law student gets and what a engineering student gets. If you are not in the top three IITs, you are nowhere. And if you see the persons who are in the top IITs, what they do, they get the BE degree, then they go to management, study management, go out and do service in bank, customer solicitation. Is this the work? But you see, a lawyer, you study law, then what options you have? You can become a very good lawyer, which I see in you all of both, those who have argued. You can go to corporates. You can be in judicial services also. And there are many of fields which you can go. So first you have to be focused that where I want to be. If you have any dilemma or any questions in your mind about your careers, father is there, all the teachers are there. They know how you are, who you are, and what is your capacity. They can guide you properly. Don't hesitate to talk to them. And I'll not take much of your time, but in life, you have to jot down your priorities. In profession also, wherever you are, either you are a lawyer or a judge or in corporates, you have to jot down your priorities. Now I'll ask you just two or three. What would be your first priority? Anyone? Yes? Yes? Teaching. This is very good. This is, I said, priority in your life. Teaching is one of your priority through which you can go, where you can go. What is your priority in your life? Which activities you will give priority? This will be the first activities, the first focus, second focus, third focus. Okay, since we are short of time, I'll say the first focus which each of you, including me and all sitting here, is would be on your health, your mental health or physical health. If you don't be focused and be disciplined and you keep your health as a first priority, you can do nothing. You may be very well prepared in a particular case, but you don't have a very good sleep, your entire effort will go to the drains. So what I would say this lastly, that you are the future, you are the voice of the voiceless. So you first be composed, calm, and you will take the world as you will go out of this campus and be disciplined, because you are in a once you wear this black coat and gown, you are in a disciplined service. This discipline will, if you have this discipline, the sky is the limit. Thank you very much.
Thank you, esteemed guests. Your words are sure to have inspired us all as hopeful practitioners of the legal discipline which we now call our own. We would now like to request a member of each of the two finalist teams to share their own experiences of THEMIS 2024.
Good afternoon, everybody. I'm Nabiha. Um, yeah, so as for my experience over the past 3 days, I think it has been very eventful. The first day was, although it was sort of, it was eventful, but the second day, I think, just surpassed everything in terms of everything that happened to us, but also through the round of the moot court. I think I definitely did learn a lot because this was my first proper moot. And There's a few suggestions I would like to make, if that's okay. For the conduction of the moot itself. Firstly, that the with regards to like the performance of the moot, mooting, as I've come to understand, is like a very formal uh, competition, and thereby it makes sense for the formality of the competition to emanate from every single activity that's done. So yeah, that's just one consideration that I had. And as for the experience that I had and the things that I learned, I definitely learned how to conserve my time while speaking. Definitely learned to grasp at the root of the question that's being asked and not sort of make circular arguments. Um, and yeah, I think this was definitely a great learning process, and I'm glad I came to Lavasa all the way from a very far place, 3 hours away from the airport, no Uber. But yeah, it was great. No, like it's a pretty good place, and I would come here again uh, if I get the opportunity. So thank you so much for that. Thank you so much for everything.
Very good afternoon, everyone present here. So this was my first moot court experience, and I was literally shivering when I gave my preliminary round that what is going to happen. So it was, yes, wonderful experience. The place is so nice. Lavasa campus is so nice. And the judges of moot court rounds were actually nice, and the queries that they were putting, that queries actually make us think that how to answer and how to get over this, and that is a part of nurturing. So it was a great experience. Well, and that's it. No, and just a one suggestion that regarding food, that no one are well versed with the tea. Like I have never drink tea in my life. I first time drank over here, so please keep alternative of coffee as well.
Thank you, participants, for your fruitful insights. We will imbibe all of it and make sure we better the experience for all stakeholders in all future events. Now, for a touch of nostalgia, let us view a carousel of precious moments of the last 3 days, specially curated by our own talented media team.
Huh? Wait, wait, wait. Just put it very close.
Now, I'll take this opportunity to call upon stage the program coordinator for the School of Law, Mr. Chetan Dikshit, sir.
Yes, I hate testing patients. That everybody knows. Seriously, there were few, observations made by those two candidates, sorry, participants, we say, and it was surprising fact. I know I'm going to announce the results, and I hate testing patients. It was very surprising fact. Both the candidates, both the participants were first year, first time. This was your first mood, right? So it is really nice experience for you also, right? One person said, "I know I hate testing patients." Uh, Coming to Lavasa was really nice experience. But the moment you enter into this place, 100% sure that it's a relieving experience. Winners are getting 1 lakh rupees. Runners up 70,000. Three best 25,000. Rich people, butterflies, entire forest, right? So yes, uh, results are with me. Results are ready. Winners are also decided. Winner is decided. Runner up is also decided. Best speaker is decided. Best memorial is decided. I hate testing patients. Best, every best is decided. So how should we go, Prakriti? How should we go? First best, right? Then runners up. No, then winner directly. Okay, 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 Father. Okay, Honorable Justice. What is this cheat? Where are the results? I told you to keep it here, no? It is also not. Oh, thank you, sir. Seriously, I was tensed because everyone is hungry as well as angry. Because prelims, your quarters, your octa, your quarter semifinals, everywhere I did not test your patience. So I'm going to announce the best first, and the best speaker is. I'm requesting our beloved HOD to declare the result.
He didn't tested the patients at all. Chetan, this is empty. Nothing is there. Okay. I cordially invite Father Justin Varghese to the stage. The best memorial goes to GLS University, Ahmedabad. Okay. 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 The best researcher, Utkarsh Sanjay Vyas, and I invite our director, Dr. Lijo Thomas Father, to the best speaker goes to Akshobhya Paul, ILS College, Pune. Now the big prize and prizes. Any guess? The runner-up, winner. Okay. The winners of fourth edition of THEMIS is will be declared soon. For that, for awarding the prizes, I invite Honorable Justice Anand Sen and Professor Swati Jogesh, along with both fathers, Father Lijo Thomas and Father Justin Thomas. The winner is TCU 8. And they represent Karnavati University, Gujarat. Yeah. The runners up As everybody knows, it is CCU 30. They represent Gujarat National Law University.
Wait.
1 minute. The speciality of this team is two of the members are from first years. Thank you.
At this juncture, I would like to once again invite upon stage Chetan sir to deliver the vote of thanks.
Obviously, I'll not be testing patience right now because I know we all are hungry and we need to go back as soon as possible. But this is not just a formality because those whoever are traveling from your respective places to Lavasa, everybody knows how apparently difficult it is. It's challenging. So, organizing this kind of competition in such a place, that challenging part becomes very easier when you have a very strong hand behind you. With a strong hand, our Dean and Director, Father Lijo Thomas, and Academic Coordinator, Father Justin. What is needed for an organizer? Go ahead. These two words. And with these two words, these two fathers were continuously along with us. People are there behind us, but these fathers were along with us. So I thank you. I express from on behalf of Moot Court Society fathers to be with us all the time. There were very new things there this time we have added, and that is with reference to Instagram page, all those reels. Whoever directly, indirectly connected with those reels, obviously including myself, we all require this kind of vote of thanks. So I am thanking all those people who are directly, indirectly connected with the organization of this competition, all those committees, all those respective heads, hospitality, logistics, food committee, everybody has been working tirelessly. So a huge round of applause of all those people who were directly, indirectly connected with that. Those whoever are sitting here right now, coming from outside, resolving your queries. Management provides support 24 by 7. When one team had come, I still remember the name of that block, not the name of that team. That is G3002. There was an issue, and it was solved in midnight. I think 12:30 to 1 p.m. It could happen because of Javed sir. All these travel arrangements are possible because of Ali sir. These two people are constantly working 24 by 7. All those who are not connected with the Christ, let me tell you, Anytime you call them, they will respond. Anytime. So that issue got resolved. I know it was a panic situation at that time for those people who were staying there for a specific 002, but it was resolved, I think, before 1. So along with that, many times there are genuine emergency demand. And the most difficult part for organizer is how to ask. This is just last minute change, and will they provide us? No way they could say no, because that person was Datta Bhau. That person was Datta sir. Because that person was Sandeep sir as well. Because there were last minute changes. There were last minute issues connected with the organization. It was very much easy for us to accommodate everything, and we could have very good solution, I'll tell you. This is not just a philosophy to follow. That's why I personally feel vote of thanks is not just a formality. It is much needed task to do. Because we have been doing the same, not obviously not for any selfish motive. We do it for organization, right? And I'll tell you one thing. If I don't mention that person, this entire thing is meaningless. A person who is really backbone of school of law, person who is really, who, if this person is there, then you don't worry, irrespective of your committee, irrespective of your event, irrespective of anything, and the person is Arjun sir. Without his support, it is not at all possible. And specifically, I'm addressing to those who are not from Christ. I'll tell you one thing. You have your own admin, right? Your admin has specific defined R, right? This person does not have defined R. Admin doesn't stay back, right? He was staying till 11:30. I was asking me, hey, go home. Obviously, he has a family. But still, he was staying back. For us, it was very relieving experience, sir. Because the moment Arjun sir is there, okay, somewhere, somehow, he will find a way and he will relieve us. And he has all those bypasses. Obviously, legally valid, reasonable excuses. Legally valid, reasonable bypasses he has. So, thank you so much for that. All those faculty colleagues who were directly indirectly connected with this competition, without them it was not at all possible. As far as organization is considered, there are few on the spot demands, and if you have a very good faculty team along with, it's very easy. Especially, again, I'm addressing to those who are coming from outside. There are last minute changes will happen for sure. You call any of our faculties, I'll tell you, no faculty will say no. For us, what else is needed? So I'm thankful for all the faculties who have been continuously supporting us throughout all the programs. Specifically, now I'm dedicating this vote of thanks for those faculties who have supported us directly, indirectly, without hesitation. Because generally in other institutes, what do we say? Hey boss, this is your committee, no? You do it, no? Why should I be there? No one says that. What else is needed? So thank you so much for all your continuous and consistent support. Hey, Prakriti, I'm not missing anybody, right? Huh. So in case if I may see, such a nice interaction we have. I could ask Prakriti, am I missing something? Such a nice faculty they have, right? Who is so humble, who doesn't shout, right? I have never shouted, right? Throughout, even before 10 minutes also, I did not shout, right? Huh. So last, not the least, again I am expressing my vote of thanks to all those volunteers. I was scolding them. I was shouting at them. But I'll tell you one thing I really liked that should be appreciated, that should be conveyed, that they did not put their moral down. What else is needed for an organizer? So at the last, again, this is not just a formality. That's what I wanted to do this vote of thanks from the bottom of my heart, not just a formality. Otherwise, I would have had a specific document. Because this is a document, this is the list I should not follow, I should not forget, and I should finish it within 1 minute. So, last but not the least, all the sweepers, whoever has continuously cleaning or all the floors. Again, those who are coming from outside, sweepers don't stay back, right? The moment their time is over, they goes back, right? Here where there were few ladies, few thais we call, few akka we call, they were here to support us till 7:30. So considering that part, we should appreciate them. So that is with reference to that. IT team, CDL, first time we had this YouTube streaming. So entire CDL team, Arjun sir and your associates, you also deserve really what this kind of vote of thanks from the bottom of my heart. entire IT team, they also they also need appreciation. So he's simply smiling. Actually, where you waiting for your name? Okay, you should have been. Okay. So along with that, I'm concluding my vote of thanks. Right? Obviously, I should not test the patience because now it's hungry and angry. Yes. Sorry. Vedika madam. She should have been here. Okay. Now the thing is, sorry, I'll take more 10 seconds. That's the problem. That I in the script her name was not there. I'm married. I have a daughter. For 3 days, Vedika did not call me, and she was not at all angry on me. Boss, you are there. You are doing something. Okay, proceed. For a husband, what else is needed? Because the biggest problem is, hey, hello, what are you doing? It's 11. It's 12. Come back. No. So she supported me. So I should express vote of thanks. So anything left? I hope nobody is left. That's what I was looking at. And yes, we have each and every college has it, and this success depends upon not only on the volunteers but the person who is leading that. So I congratulate Prakriti for organizing this THEMIS and all the supports which was unconditionally given by all the volunteers. Again, I wish I could take name of each and every volunteer. It would kill more 20 minutes, so I'm avoiding it. And again, it is not just a formality. Somewhere, somehow, you need to. Last but not the least, I have. I'm again. You tell me, hey, anybody is being missed. Thank you so much. No, yes, the person who is equally responsible for conducting this entire theme is Sugam sir. The person who was continuously staying back with us late night. A person who was there along with us to guide us. Not many times we think certain words are used just as a hierarchy of authority. Many times, head is not with heart. Our head has heart. So, our beloved HOD, Dr. Anto, I'm expressing deepest gratitude for rendering your unconditional support. Last but not the least, a person who did not test your patience. All the participants, all the judges, thank you so much for coming here, for blessing our students, for blessing the participants. Thank you so much.